we stand to thee, alma mater, flame of love that beams shining brighter, helmet shall we cheer forever, love and service all we uphold. It's the pride of dear Visayanya, joyful hearts we sing together, seek the truth, the fountain of knowledge, go live alma mater near. Visayas, go, go, go! Love and serve humanity, with the heart we love to see. We will always need a way as to thee. We say onward, keep the UV spirit burning. Our beloved dear alma mater, with our hearts we pray forevermore. Visayas, go, go, go! Love and serve humanity, with the heart we love to see. We will always need a witness as to thee. We say onward, keep the UV spirit burning. Our beloved dear alma mater, with our hearts we pray forevermore.
Good day, everyone, and welcome to Statutory Construction. You might ask, unsa maning statutory construction? Why is this needed? Just remember na statutory construction will come in if there is a doubt and confusion with the meaning of the law. And because of this doubt or confusion or infirmities of the language and the limited scope in legislative drafting, inevitably there enters into the construction the statutes, the play of judicial judgment within the limits of the relevant legislative materials. Remember that when we talk about construction, this comes from the verb construe. And when we talk about construe, this is to determine the meaning of the words of a written document, a statute, or legal decision based upon rules of legal interpretation as well as normal meaning. So this does not come from the word construct, ha? This comes from the verb construe, meaning to determine the meaning of the words. All right? So how do we define statutory construction? Statutory construction is the art or process of discovering and expounding the meaning and the intention of the authors of the law, where that intention is rendered doubtful by reason of the ambiguity in its language or of the fact that the given case is not explicitly provided for in the law. It is basically the drawing of warranted conclusions respecting subjects that lie beyond the direct expression of the text, or conclusions which are in the spirit, though not within the letter of the text. In your study of statutory construction, you will come across maxims to the effect that it would really tell us na the laws should be interpreted not by the letter that killeth, but by the spirit that giveth life. So, ani ang construction. Kung naay doubt, kung naay confusion with respect to the interpretation of the law, you always try to find out kung unsa may spirit aning balaod na. So, the rules of statutory construction are basically tools used to ascertain the legislative intent. They are not rules of law, but these are mere axioms of experience. Okay? Kung ang legislature, once they enact a statute, it is actually presumed na they know the rules of statutory construction. The legislature enacts a law with the end in view that it will, in case of doubt, be construed in accordance with the settled principles of interpretation. So, di pwede nga mag-draft-draft lang silang balaod without knowing the rules of construction or statutory construction, because there will always come a time wherein the interpretation of a particular law is kind of doubtful or confusing. So, ang buhaton sa judiciary would be to go down to the basic rules of statutory construction. Alright? Mao nga, we always say nga where there is ambiguity in the language of a statute, courts basically employ canons of statutory construction to ascertain its true intent and meaning. Alright? Pero you also have to remember nga, ang statutory construction does not actually solve the special difficulties in construing a particular statute. The variables actually render every problem of statutory construction unique. Maunang for this reason, the courts may actually utilize in construing a statute not unambiguous or a statute which is ambiguous all the light relevant shed upon the words and the clause of the statute that express the purpose of the legislature. Okay? Di na siya mo focus with one canon of statutory construction because dili na makasulbar with a particular confusion. Alright? It doesn't really mean nga nanakay axiom or nanakay principle of statutory construction automatic na it can solve your issue with respect to a particular statute. Kaya nga naman, because ang statutory construction or the problems underlying statutory construction is actually unique. Mo na nga ang mga korte, they can always utilize mga rules of statutory construction that would basically give meaning to the words and to the clause of the statute to the effect that it would express the purpose of the legislature. Now, there are instances wherein the legislature adopts rules of construction as part of the provisions of the statute. Mismo ang balaod nag-ingon nga this is how should this particular article is interpreted. Okay? There will come a time wherein you can come across the laws wherein ang balaod mismo, ingon siya, in case of doubt in the interpretation or applications of law, it is presumed that so and so. Okay? Like Article 10 of the Civil Code. Article 10 of the Civil Code, if you can remember, it says that in case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. Also, later on in your study, as you progress in the study of law, you will learn in labor code na nag-ingon na dito nga all doubts in the implementation and interpretation of the provisions of the labor code, including its implementing rules and regulations, shall be resolved in favor of labor. Okay, you will learn that later. Also, in your study of special penal laws, you will come across this provision, particularly Section 5 of RA 7160, with respect to the interpretation of the provisions of the Local Government Code of 1991. So, dito gi-enumerate sa legislature on how is a particular provision or how is a particular power of the local government is interpreted. So, mo ning mga instances wherein ang balaod mismo nagbutang og pamaagi on how do we interpret or how do we construe a particular provision of the law. But absent which, you always go down to the canons of statutory construction. Okay? Kibaw ko, kamo karon nag-wonder mo, why do we have to study statutory construction? Like you, when I was in first year, I also had the same question, And back then, our professor would ask us to really memorize all the Latin maxims found in the book of Agpalo. And we would happily oblige because paminaw na mo atong time, bright kay may mo memorize og mga legal maxim, di ba? Duralex, Sidlex, and all that. But later on, when I started practicing as a lawyer, I realized that the study of statutory construction was really of paramount importance. Nga naman, because later on in your practice, you will come across issues wherein the language of the law would seem very confusing. But then again, when you examine it, dito nimo makita nga maumanday ni ang gipasabot sa balaod. Let's take for example kanilang inyuhang problem in law school with respect to the law on marriage, 'di ba? We've discussed Article 26 of the Family Code with respect to divorces abroad, 'di ba? And there in paragraph 1, of Article 26, you would see that naingon ang balaod marriages outside of the country which are considered to be valid therein shall also be valid here in the country, and then you are faced with a problem between same-sex marriages. And when you are asked this question, basically kung mubasa lang ka sa paragraph 1 of Article 26, makain ka, yes, this is valid. But when you examine the intent of the law of the family code, particularly Article 1, you would then discover the marriage should be between a man and a woman. And then you would also realize nga naa pa di ay Article 15 of the new Civil Code. So ani ang mamahimong role sa statutory construction in your study of the law as well as in the practice of the law. Also, puhon makakama-cross mo law on child abuse kaning RA 7610, makit-an sa ninyo dito kung how does the law defines the term child. Nga ang child is not just limited to persons below 18 years of age. It would also cover persons who are incapable of taking care of themselves. So ana ka-importante ang statutory construction. But remember nga, as instruments of construction, they only are used to clarify and not to defeat the legislative intent. And even those rules of construction which are in the form of statutory provisions may be ignored if their employment may defeat rather than effectuate legislative intent. Nga naman, kay ang cardinal rule gyud when it comes to interpretation of all our laws is to really ascertain and give effect to the intent of the law. Hence, all the rules of construction or the interpretation have for their sole object the ascertainment of the true intent of the legislature. The object of all judicial interpretation of a statute is to determine legislative intent. What intention is conveyed, either is it expressly conveyed or impliedly conveyed by the language used, so far as it is necessary for ascertaining whether the particular case or state of facts presented to the court comes within it. Alright? Now, you might ask, unsam din ang legislative intent? Legislative intent, ladies and gentlemen, is the vital part, the very essence of the law. Maunay rason nganong naay balaod. Maunay reason why Congress decided to draft or craft that law. Okay? So the intent of the legislature is basically the law and the key to and the controlling factor in its construction or interpretation. Intent is the spirit which gives life to legislative enactment. It must be enforced when ascertained, although it may not be consistent with the strict letter of the statute. Courts will not follow the letter of the statute when it leads away from the true intent of the legislature and to conclusions inconsistent with the general purpose of the act. Hence, where a statute is susceptible of more than one construction, the construction should be adopted which will most tend to give effect to the manifest intent of the legislature. Mao ginay atong timan-an. When it comes to construction and interpretation of laws, you always have to find out kung unsa may legislative intent ani. Unsa man ang rason why this law is crafted by the Supreme Court. Diha musod ang purpose and meaning of the statute. Alright? Kung mayroon ka og legislative purpose, mao na siya ang reason why a particular statute was enacted by the legislature. Unsa may gusto sa legislature nga ma-achieve or ma-accomplish by enacting this particular statute? What is its object? Is it enacted in order to prevent a mischief? Is it to create new rights? Or is it to eliminate defects in existing laws? Or is it to implement strict provisions or mandates of the Constitution? Ang mga answer ani and similar questions posed earlier would be the so-called purpose of the law. Remember na a legislation is an active instrument of government, which, for purposes of interpretation, means that laws have ends to achieve, and statutes should be so construed as not to defeat but to carry out such ends and purposes. Kung mayon sa kag-legislative meaning, this is what the law, by its language, means. What does it comprehend? What does the law cover or embrace? What are its limits? Or where are they confined, 'di ba? These questions, when they are asked, basically, mao ni siya ang magsulti nimo kung unsa ang legislative intent. Now, kaning kaso sa Minoru Takashi versus Republic basically is an illustration of the term legislative intent and its component concepts. Diri nimo makita how the Supreme Court explained the purpose and the meaning of Article 26, particularly paragraph 2 thereof of the Family Code. Okay? What actually happened in Minoru Takashi, if you recall, this was actually a petition for judicial recognition of divorce between Takashi and his former wife, Filipino nga wife nga si Morania. And ang dispute ani is whether or not ang Filipino wife can actually file a divorce decree outside of the country, no? And dili ang foreigner. Because in the past, ang jurisprudence would tell us nga the person who can only file for or who can only obtain for a decree of divorce is the alien spouse. But with the recent jurisprudence handed down by the Supreme Court in Republic versus Manalo, as well as in this case Minoru Takashi versus Republic, diri gyud gi-clarify sa Supreme Court kung unsa man gyud ang pasabot sa paragraph 2 Article 26 of the Family Code. And I will read the pertinent decision or the pertinent portion of the decision of the Supreme Court wherein statutory construction is very apparent. Ningon ang Supreme Court to reiterate the purpose of paragraph 2 of Article 26 is to avoid the absurd situation where the Filipino spouse remains married to the alien spouse who, after a foreign divorce decree that is effective in the country where it was rendered, is no longer married to the Filipino spouse. Whether the Filipino spouse initiated the foreign divorce proceeding or not, a favorable decree dissolving the marriage bond and capacitating his or her alien spouse to remarry will have the same result. That is, the Filipino spouse will effectively be without a husband or a wife. A Filipino who initiated a foreign divorce proceeding is in the same place and in the like circumstances as a Filipino who is at the receiving end of an alien initiated proceeding. Therefore, the subject provision should not make a distinction. Further, the Supreme Court would tell us, ingon pagyud siya nga, indeed, where the interpretation of a statute according to its exact and literal import would lead to mischievous results or contravene the clear purpose of the legislature, it should be construed according to its spirit and reason, disregarding as far as necessary the letter of the law. A statute may therefore be extended to cases not within the literal meaning of its terms so long as they come within its spirit or intent. So ningon ng Supreme Court no na the purpose or the reason nganong naay legislature is basically to protect our own nationals. And if we prohibit the Filipinos from participating in divorce proceedings, it will not be protecting our own nationals. Therefore, ningon ng Supreme Court, verily, even though it was the petitioner herself or who jointly filed with her husband, for and obtained the divorce decree in this case, the same may be recognized in our jurisdiction. Sumoto guys ha, ang Minoru Takashi versus Republic. That's the latest jurisprudence with respect to the interpretation of the paragraph 2 of Article 26 of the Family Code. Now, you also have to remember that in construing a statute, it is not enough to ascertain the intention or the meaning of the statute. It is also necessary to see whether the intention or the meaning has been expressed in such a way as to give it legal effect and validity. In short, according to Agpalo, the object of the inquiry is not only to know what the legislature meant by the language used, but also to determine whether the language used sufficiently expresses that meaning. So now, we already understand the concept of statutory construction, the legislative intent pertaining to the purpose and the meaning of a particular statute when there is ambiguity or when there is doubt or confusion with respect to its interpretation. So we now go to the question kung which branch of the government is vested with the power to construe. We mentioned earlier that the power to construe is basically a judicial function, okay? The duty and power to interpret or construe a statute or the Constitution belong to the judiciary. It is the duty of the legislature to make the law, of the executive to execute the law, and of the judiciary to construe the law. Okay? Sayon ra kaayo nimo sabtan ng tulo ka branches basically, 'di ba? Tulo ka branches, legislative, judiciary, executive. When we talk about the legislative department, what they do is they make the laws, right? When we talk about the executive, they execute the law. Pero when it comes to the construction, the power to construe, it is vested with the judiciary. It is emphatically the province and the duty of the judicial department to say what the law is. And while the legislative and the executive departments, by enacting and enforcing a law respectively, may construe or interpret the law, it is the court that has the final word as to what the law actually means. Okay? And remember that the legislature cannot overrule judicial construction. Okay? The legislature has no power to overrule the interpretation or construction of a statute or the Constitution by the Supreme Court, for interpretation is basically a judicial function assigned to the latter by the fundamental law. Klaro kay na sa Constitution. While the legislature may indicate its construction of a statute in a form of a resolution or a declaratory act, it cannot preclude the courts from giving the statute a different interpretation. Okay? And when a judicial interpretation is actually done, this doesn't mean na forever na siyang naadira, okay? This may also be set aside. The interpretation of a statute or constitutional provision by the courts is not so sacrosanct as to be beyond modification or nullification. The Supreme Court itself may, in an appropriate case, change or overrule its previous construction. In your readings, kebaw ko daghan na kay mong kaso nga nabasa because you've been digesting a lot of cases, you will see the modifications and the evolution of the decision of the Supreme Court. And usa lang sa mga example ani wherein the Supreme Court set aside its own interpretation is kaning sa Minoru Takashi versus Republic, as I've mentioned earlier. In the past, the Supreme Court would say nga the only individual who can always file or who can only file for a divorce or who can obtain for a divorce decree is only the alien spouse. Pero lately, no, because nag-evolve naman pod ang thinking sa Supreme Court, karon niingon na ang Supreme Court giset aside nila to ang ilang decision in the past, and now the Supreme Court would tell us nga pwede na ang Filipino spouse. Pero imo lang yun na siyang hinumduman nga paragraph 2 would apply to mixed marriages. Okay, kailangan at the time of the divorce, mixed na ang nationality sa parties, usa alien, usa Filipino. Alright? I hope that's clear, guys. And I want you to remember, no, I emphasized earlier nga mo come into play lang ng statutory construction if there is ambiguity or if there's doubt or confusion with respect to the language or interpretation of the law. Okay? A condition sine qua non before the court may actually construe or interpret a statute is that there be doubt or ambiguity in its language. Because the province of construction lies wholly within the domain of ambiguity. Kay kung why ambiguity, guys, in the words of the statute, there's no room for construction. Okay? Only statutes with an ambiguous or doubtful meaning may be subject of statutory construction. Now, you may ask, unsa din ang ambiguity, ma'am? What is ambiguity, attorney? Ambiguity simply means a condition of admitting two or more meanings, or of being understood in more than one way, or of referring to two or more things at the same time. Okay? Mura ba ka ng nananguyab nimo o niya imuhang gipaasa ba? Okay? If di ka ganahan niya, so nga di ka ganahan. Ayaw og pag-manifest og physical manifestation as if ganahan ka. Because ang imuhang physical manifestation would be interpreted as being ambiguous. O diba? Mo-apply na noon na siya ron og statutory construction. Simply put, ladies and gentlemen, a statute is ambiguous if it is susceptible of more than one interpretation. And in such a case, the court should construe the statute and give it a meaning that is in accord with its intent. Pero just because courts are vested with the power to construe doesn't mean nga they can, in the guise of interpretation, enlarge the scope of a statute and include therein situations not provided nor intended by the lawmakers. An omission at the time of the enactment, whether careless or calculated, cannot be judicially supplied. However, later wisdom may recommend the inclusion. Okay? Courts are not authorized to insert into the law what they think should be in it or to supply what they think the legislature would be supplied if its attention had been called to the omission. They should not, by construction, revise even the most arbitrary and unfair action of the legislature, nor rewrite the law to conform with what they think should be the law. Because ang judiciary is solely vested with the power to construe, not to make the laws. Okay? Pero, however, pwede nga mo recommend ang judiciary, di ba? Later on, as a form of wisdom, pwede nilang i-include therein their recommendation, but never to add nor revise the law. Alright? Now, if ang meaning sa statute is ambiguous, the court is actually warranted to avail itself of all legitimate aids to construction in order that it can ascertain the true intent of the statute. Okay? These are the so-called intrinsic aids and extraneous or extrinsic aids. When we talk about intrinsic aids, these are found in the printed page of the statute. Okay? Intrinsic, nasa sud sa statute itself. When we talk about extrinsic aids, these are extraneous facts and circumstances outside the printed page. Okay? Unsa man ning mga intrinsic aids? Mao ning title sa statute, mao ni ang preamble, diba? Ang preamble sa statute, ang mga punctuation marks, the context of the whole text, diba? The capitalization of the letters, headnotes or epigraphs, lingual text. When we talk about extrinsic aids, mga dictionary, mga legislative history, diba? Mga deliberations of the committee, legislative debates, views, and deliberations to that effect, mga reports of the commissions. These are the aids to construction that the courts may avail itself of in order for them to properly arrive at a conclusion or interpretation. Okay? So those are the aids to construction, ladies and gentlemen. Okay? Next meeting, I will finish discussing the other principles found in statutory construction. But to recap, I want you to remember that in order for the courts to actually construe or interpret a statute, there has to be doubt or ambiguity in its language first. Okay? And I'd also like you to remember the concept of statutory construction to the effect that you have to consider that it is an art or process of discovering and expounding the meaning and intention of the authors of the law, where that intention is rendered doubtful by reason of the ambiguity in its language or of the fact that the given case is not explicitly provided for in the law. To those who have not yet submitted their assignments, I suggest you submit them within the day in order for me to check if complete ra ang inyuhang assignments and in order for me to determine if I have to give another assignment or proceed with the conduct of the examinations. Thank you very much, everyone. Good evening. Amping.